we have discussed this situation with Ms. Trant, and I'll remind the council and Ms. Trant that the terms of the order that we entered on May the 30th say that the court found you to be in willful contempt of the court. So we've already made that finding, okay? You've indicated through counsel this morning that you'll be able to file a brief in State versus Rollins within a week. We're going to enter a follow-up order and state that if it appears to the court that that brief was filed before noon on whatever a week from today is, I haven't bothered to look it up, next Tuesday.
Yes,
Then the matter of contempt will stand, but it'll be a closed matter upon notifying the BPR that we have made that finding. And that would be the last order entered in the case. However, if that order is not, a brief is not filed by noon next Tuesday, we do not intend.
May it please the court, Nathaniel Evans from the Knoxville Bar. Representing Mr. Chism, I'd like to reserve 5 minutes, Your Honor.
5 minutes.
Yes, Your Honor.
All right, thank you.
Your Honor, there are two issues that are primarily raised in this appeal. And I think with respect to both, a sequence of the basic facts in this case, not to belabor points that have already been raised or facts that have already been raised in my briefs. But this involved an officer encounter, a random officer encounter whereby Officer Arnold, the principal officer in this case, was at a pilot travel center eating when he observed two individuals walk into that pilot travel center. One of them was Mr. Chism. The other was a co-defendant that was not tried in this case, Ms. Kelly. To date, Ms. Kelly has not been tried or found. When they walked in, Ms. Kelly was acting hyper, and Officer Arnold believed that she was she could potentially be under the influence of some drugs. That accusation was never made with respect to Mr. Chism. Officer Arnold felt that he had to investigate the situation and ultimately encountered the two of them outside in front of the pilot travel center. At that time, Officer Arnold, I think there was a citizen encounter that was effectively instigated, in that Officer Arnold was asking both of them questions. General questions about where they were coming from, and I think generally getting a beat on what Ms. Kelly was up to and what her condition was. A second officer, Officer Gwynn, came shortly thereafter, and during this citizen encounter, Officer Arnold discovered or heard two different stories about where Mr. Chism and Ms. Kelly had come from. Based on this, Officer Arnold requested from Mr. Chism his license and ID. Mr. Chism provided his probation ID. And at that point, Your Honor, we submit that Mr. Chism was seized for Fourth Amendment purposes. Under State v. Daniel, his property, his identification, his only form of identification that he had on his person. Although I acknowledge that he did say that he had a license, he could not find it or produce it, but he did give to Officer Arnold his probation identification. And it's at that point, Your Honor, that we submit he was seized. I think the state's raised the issue that after that seizure, and this can be seen on the video, Officer Arnold does permit Mr. Chism to go back into the Pilot Travel Center to get a couple of other matters or other things for his hot dog that he was eating. And he was permitted to continue to eat his hot dog, somewhat comically as how that plays out in the video. But Mr. Chism was never outside of Officer Arnold's sight and was never given permission really to be outside of Officer Arnold's sight. As soon as Mr. Chism asked to go to the bathroom, Officer Arnold denied that request. Now, there is one thing that happens and after that seizure, there is some conversation where Officer Arnold, who did not see the pair arrive, who has no information as to who was driving, where Officer Arnold, and this fact gets a little bit muddled throughout the different transcripts. At the suppression hearing, Officer Arnold almost unequivocally states that Mr. Chism stated that he was driving in a past tense. At trial, Officer Arnold indicates more like, well, he is somewhat more accurate in what happened on the video and saying that, he took some things together to say that he thought Officer Arnold was driving, that Mr. Chism was driving. And on the video, there is clearly some joking where they're talking about Miss Kelly's condition, and Mr. Chism does make one statement. The only statement that he makes is like, I wouldn't let her drive me anywhere. And I think that's the point. And that prospective statement in terms of what he would allow to happen is critical in terms of because what happened in the past, there is this assumption that Mr. Chism was driving because Miss Kelly was hyper. However, I think what gets lost in the shuffle a little bit is that Miss Kelly, it's unclear when Miss Kelly got high. This is not a case where the officers found Mr. Chism and Miss Kelly driving. This is a situation where she clearly has access to drugs and is clearly high at the time she goes into the Pilot Travel Center, but there's no indication of when she got high. And to take first the issue of the constitutional seizure, without the statement and we submit that following that seizure, that seizure was unreasonable because Officer Arnold did not have specific articulable facts to take Mr. Kelly's probation identification, because at that time, all he knew was that Miss Kelly was may have been under the influence, and that the two told different stories. By itself, that is not sufficient to support reasonable suspicion. And
so, counsel, help me with this.
Sorry.
I appreciate it. I don't mean to interrupt. I have a threshold question that I'm having a little bit of trouble getting over. What is the Fourth Amendment issue that you're raising? And this is the background from which I'm coming at it. The original motion to suppress is not contained in the record, or at least I couldn't find it. It does appear that the transcript is, and so I can see where that is, and I can also see the court's order from the original motion to suppress. The motion for new trial raises just about as broad an issue as you can raise. Was evidence improperly admitted in violation of the Fourth Amendment in Article 1, Section 7, without any narrowing at all. So it apparently encompasses the whole of Fourth Amendment jurisprudence. At the hearing on the motion for new trial, though, we're focused, it looks like, exclusively on the scales. And so the only discussion between trial counsel and the court relates to the discovery of the scales. Not talking about the statements, not talking about any of the other things. And I think the court's order then relates to that. We come up on appeal, and the appellate issue is, was evidence, including statements, scales, and others, offered in violation of the Fourth Amendment in Article 1, Section 7. In other words, I have very respectfully, an incredibly general issue statement. And from that, how am I supposed to know, or how could I know, what it is the court's actually being asked to decide? Am I limited to what was discussed on the motion for new trial? Sounds like you're
I would
asking me
submit
to.
that in that hearing, with respect to what trial counsel stated, and trial counsel did make the point, and I raise it again, he made the point that the seizure was unlawful. And I think, and he then goes on to make the point, and the point that I'm trying to make, and I think that obviously I've spent a little bit more time trying to articulate this than trial counsel, and I've just an opportunity, as I think one has when one does an appeal. Trial counsel makes the point that there was an unlawful seizure because of the taking of the ID and the fact that there was not sufficient information for an officer to do that. He then does focus on the scales, and I would argue the same thing. There is a...
If he does that, you would agree with me, he does that in passing. I mean, there's not an opportunity where the trial counsel says, Judge, we raised these facts on this issue, and you made this ruling, and I'm contending that's an error. I mean, that doesn't happen in the motion for new trial, does it? I mean, it's a 13-page transcript total, or roughly. He mentions that in passing, focuses on the scales.
He does, but at the very beginning, he begins to talk about that. He does discuss that sequence of events and does note that there is, and he does note the unlawful seizure as the starting point. And I would submit, Your Honor, that this is a somewhat complicated, and at times I've thought tortured, but when I've thought about it more, I think it makes sense in that there's both a seizure issue and a probable cause issue. I mean, in terms of the seizure, if you don't get to the scales.
I think that's my issue. How do I know what Fourth Amendment issues you're actually raising when the issue statement was evidence seized in violation of the Fourth Amendment? I mean, if I were writing the opinion, how far down the rabbit hole do I go in terms of trying to identify what the Fourth Amendment issues are and then resolving them?
I think, as with any Fourth Amendment issue, when you raise it, the facts become, when you raise a Fourth Amendment issue, there are times, I think, as in this one, where the sequence of events is critical, and there can be multiple points during that sequence of events that can create Fourth Amendment violations.
I agree.
And even in this case, the court noted, after the court did suppress statements, obviously not necessarily Fourth Amendment issues, but the court notes that there is, in the sequence of events, a constitutional violation that occurs post-arrest, and offers a remedy for that. The court also, in its ruling, and the state, I think, also further kind of muddles this in terms of, first, the court notes, with respect to the seizure, the court touches on this, that the officer has the right to see. The court effectively says, the Officer Arnold had the right to seize Mr. Chism because he had to investigate Miss Kelly. Because Officer Arnold had to investigate Miss Kelly. I think that's a misapplication of the law, and that it has to be specific and articulable as to Mr. Chism.
Could you do this for me, actually?
Yeah.
Maybe here just on the fly. Could you identify for me what the Fourth Amendment issues actually are that we're raising and that the court's being called upon to decide? Like whether there was reasonable suspicion to detain, whether there was probable cause. Can you just identify those issues for me so I can be clear what we're doing, please?
Whether there was reasonable suspicion to detain Mr. Chism, specifically whether there was reasonable suspicion to take his ID. So there's a question of, was he seized? And we submit that the first issue is whether he was seized,
yes, right.
And he was seized by the taking of his probation identification. At that point, was there reasonable suspicion to take his identification, or reasonable suspicion to detain him?
Okay, and then what evidence was discovered as a result of that?
The state,
All of it?
we would submit that, yeah, all of it. I think that the premise, and the sequence goes on such that Mr. Chism is in effect let go before, he's not let go because his license is still seized, but he's told he's free to go. He's calling somebody before he is arrested.
Okay,
And the
so
search incident to arrest is what resulted in the scales.
What's the next Fourth Amendment issue? Let's say that the court respectfully disagrees about the reasonable suspicion. What would be the next Fourth Amendment issue you're raising?
Well, the next Fourth Amendment issue, assuming that any statement, and again, I addressed that there's some question about what that statement is with respect to his driving.
Okay.
Because if you don't have driving, I don't think, I'm sorry, Your Honor, I didn't mean to.
No, you're fine, you're fine. Does the statement arise as part of the reasonable suspicion analysis?
It arrives post the reasonable
Okay,
suspicion.
so let's assume that, I don't know that we will, but let's assume that we disagree with you on the reasonable suspicion analysis. That takes care of the statement issue, is that correct?
Correct, Your
All right,
Honor.
is there another Fourth Amendment issue aside from the reasonable suspicion?
Yes, Your Honor. Without, I would say alternatively, even with the statement, there's not probable cause to arrest him,
Okay.
because it's, again, mere association with that car and nothing more. So I would argue that with that state, even assuming he says, prospectively, I wouldn't let her drive, the officers have two different stories and his presence in the car, and that's it.
Okay, and
In
search
terms of
incident
their
to
arrest of him.
The search incident to arrest gives rise to the discovery of the scales in the pocket.
Correct.
All right, let's assume, without deciding that we disagree with you on the probable cause analysis, are there other Fourth Amendment issues?
No, Your Honor.
Okay, all right, that's helpful, thank you.
So and I think I've just laid out the Fourth Amendment issues as I have them. But even assuming that there is, that Officer Arnold did not violate Mr. Chism's constitutional rights, even taking into account that we have the scales, and the state has really just that to cling to, and I'll have to, I guess, address that in my rebuttal. But the state only has the scales to cling to say that Mr. Chism has any connection to the drugs or gun in the car. And that is a tenuous grasp, because otherwise, without making the leap that these scales are connected to those drugs, which I don't believe is actually proved in the trial transcript, that the scales in Mr. Chism's pocket are connected to the drugs in Miss Kelly's car. Without that, all they have is mere association, mere presence, nothing more.
Morning, Your Honors. May it please the court. My name is Garrett Ward, and I'm here this morning on behalf of the state of Tennessee.
General, it
Yes, Your
seems to me, I'll make this comment, might help orient your argument a little bit, but it seems to me that the various points of connection along the path that leads up to finding the evidence that served to convict the defendant, those points all seem a little bit marginal to me. So how can you address those various, I'm talking about interactions with the defendant that properly build up to the finding that convicts him?
Certainly, Your Honor. So on sufficiency of the evidence, and I'll agree with the court that this case is largely circumstantial. I'll point the court, I think, to three pieces of evidence that I think speak to constructive possession in this case, because that's principally what this case is about. The sufficiency challenge is, as I understand it, cabin to the unlawful possession of a firearm charge. So I'd point the court to three pieces of evidence in this case that speak to sufficiency. Pardon me. First, I'll note that although his story sort of vacillates at times during his interaction with law enforcement, at times the defendant indicates he was operating the vehicle in which the cocaine and the handgun were found. And the cocaine and the handgun here are found in like a sort of a sunglasses holder compartment in the center ceiling of the car. And this court has noted in a number of cases, Signer is the one that springs to mind for me, that driving makes a difference in the context of constructive possession when it comes to cars, because that's evidence from which the jury and this court on sufficiency review can glean the mens rea for constructive possession. So I'd first point the court to the evidence speaking to driving. I believe the exact words that the defendant uses are, I wouldn't ride with her, she's too hyper, she's like this all the time. Viewing that in the light most favorable to the state, that's something that does indicate the defendant was driving this vehicle. Second, Your Honors, I would point the court to the scales that are ultimately found on Mr. Chism. When he's searched incident to his arrest, he's in possession of a set of digital scales that have some sort of white powdery residue on them. Your Honors, it's a pretty straightforward bridge from digital scales with powdery residue to a small compartment that has cocaine and a gun inside of it. I think that speaks directly to sort of knowledge and understanding of what is in this compartment. And since we're here talking about constructive possession, we're chiefly concerned about sort of intent and ability to exercise dominion and control over these items. His knowledge that they're in, that, you know, perhaps we can glean his knowledge from these scales, from the cocaine that is in this compartment. I think there's a pretty direct line between those two pieces of evidence. I sort of extrapolate on that, you know, the presence of residue on the scales does suggest to some extent that this compartment was accessed during the time the defendant was in the car, this compartment being the one with the cocaine and the firearm in it. Thirdly, and this is the last thing I'd point the court to, is the behavior with Ms. Kelly. And I want to be very careful with this court when I discuss Ms. Kelly's behavior. The state isn't suggesting some sort of guilt by association theory, but in terms of what inferences can we make about the defendant's knowledge of what's in this car, and, you know, that speaks to his intent and ability to exercise dominion and control. The fact that the other occupant of this car is visibly intoxicated, this court will be able to see the video. I believe Ms. Kelly is described by Officer Arnold as bouncing off the walls, and even the defendant acknowledges her erratic behavior. It wasn't 4 hours ago that Ms. Kelly, that this compartment was open and somebody consumed cocaine.
So, General,
it was pretty recent.
My disconnect maybe with the argument, if I'm having one, is this.
Certainly, Your Honor.
As I understood the verdict, the jury hung on the felony possession of cocaine, and that what we're here is with respect to the possession of the weapon. And so I hear lots of good links that the state is drawing between scales that he has with residue and cocaine and her being visibly intoxicated and inferring that it's a cocaine intoxication. I understand that. I'm having trouble getting to the gun. So the gun is in the sunglass visor, right?
They're essentially right on top of one another, Your Honor.
Okay. So if the state has to prove that he knew that the gun was in the car, where's the state's argument on that? Because the link doesn't seem to be as clear to me from her intoxication that he knows that A, there's a gun, and B, where it is. The fact that he has digital scales in his pocket, the link isn't as clear to me that he knows there's a gun in the car and he knows where it's at. So help me with the link with the firearm, if you could, please.
So I would start with you know, the link just in general. Both pieces of these evidence, I would start with driving. A number of cases from this court have spoke to, you know, driving, sort of linking the driver to the car in general. So I'd start there. Also, and I understand the court's concern. I'm talking a lot about a piece of evidence that isn't the firearm, but you know, factually, when we look at what happened in this case as to where these two items were, they're in a pretty, you know, it's like a pop-down sunglasses holder. The court will be able to see it on the video. They're discovered as one unit, essentially. Obviously, they're two objects, but when it comes to, you know, the actual discovery of these items by the officer who's searching the car, they're right on top of one another. There's just factually, given this case, given the proximity of these two pieces of evidence, there's just a close link between these two pieces of evidence simply because of their physical proximity. So I understand the court's concern, and I'd suggest that maybe not, certainly not in all cases, is evidence of one piece of contraband, of knowledge of one piece of contraband, evidence of knowledge of another. But in this case, I think it's fairly reasonable to suggest that it is because of where they're located and stored. You know,
And the state is having the court then draw the inference that it views as reasonable, that her intoxication is a result of the cocaine in the sunglass visor, drawing the reasonable inference that the residue on the scales in the defendant's pocket is also from the cocaine in the sunglass visor. Those are inferences we would have to draw, right, in order to connect the dots?
Those are inferences that the jury drew, Your Honor, yes.
Okay, I mean, but we would have to draw those inferences to sustain the verdict, right?
Certainly.
Okay, is there, and you can see that this is largely a circumstantial case, do you have any evidence at all that connects her intoxication or the residue on his scales to the cocaine that's found in the sunglass visor?
Candidly, nothing, there's not testimony as to, it's not like the defendant says in any of his statements to police that he was preparing or cutting cocaine. It is largely inferential. But I'd suggest to the court that, needing to view the evidence in the light most favorable to the state, and indeed needing to draw all reasonable inference in the state's favor, this is maybe not the typical constructive possession case, but there is just a chain of several links from the defendant to this compartment where the gun
Was
was
there
located.
any cocaine found anywhere else? Like, was cocaine found on the passenger? Was cocaine found in the passenger compartment otherwise? Was cocaine found on the defendant? I mean, is there any other source from which the cocaine could have come other than the cocaine in the sunglass visor?
No, Your Honor. There's the cocaine in the sunglass visor, and then there's the residue on the scales, which sort of visually appeared to be cocaine, but there wasn't independent sort of laboratory verification of that. So no, it's not as if there's cocaine strewn all about the car. There is one source of cocaine, and it's there lying on top of the gun.
Okay. Was it established ultimately, and I'll stop after this, was it established ultimately that her intoxication was a cocaine intoxication?
Not in this case, Your Honor. They
So we're
didn't.
having to infer that as well?
Yes, Your Honor, having to infer from, there's evidence at trial about sort of the stimulatory nature of cocaine as an intoxicant, consistent with her behavior, and just in general, Officer Arnold's testimony sort of describing her as being intoxicated. And this court will see the video and be able to read Officer Arnold's testimony. So no, there's not. The evidence is what it is, but in the light most favorable to the state, I believe it is sufficient to sustain this verdict.
Okay, thank you, Joe.
Addressing, Your Honors, this search and seizure issue, I think where I'd like to start is, Judge Greenholz, I think fairly similar to where you started on this issue during opposing counsel's argument, and that is, what exactly is this issue? And I think it matters for a couple of reasons. Primarily, I think there's a lot of waiver concerns with this case. Judge Greenholz, as you noted, we don't have the original motion to suppress that was filed in this case. Maybe not in and of itself as a independent waiver, but we don't have the original legal pleading here. We initially didn't have the motion for new trial or the transcript of the motion for new trial, and I think those would have been essentially fatal in terms of establishing waiver. But, Your Honor, when the record was supplemented with these, they really didn't help that much in terms of preservation of some Fourth Amendment issues. I understand my friend on the other side to be saying that there are two Fourth Amendment issues in this case. One that pertains to the scales, the sort of no probable cause to arrest, and then a second that pertains to certain statements. What's missing from the motion for new trial, Your Honor, and the motion for new trial transcript is discussion of these statements. As Your Honor noted, the motion for new trial itself just sort of generally says the evidence was seized in violation of the Fourth Amendment. No specific Fourth Amendment doctrine identified that would suggest what evidence we're talking about, and it does generally just say the evidence. And there's really very little clarification that is helpful to the defendant in the transcript. What we talk about in the transcript, and this is honestly reflected in the court's order denying the motion for new trial, what we talk about is the scales. We don't really talk about the statements. Yes, the word statement is used in the motion for new trial transcript. It is used in passing, just to discuss the defendant talking to law enforcement. It's used a bit more when trial counsel is discussing his successful motion to suppress, because there were certain statements that were suppressed at at a pretrial stage for a Miranda violation. Those obviously aren't at issue here. They weren't viewed by the jury. But most of the discussion of statements in the motion for new trial is this other, legal doctrine, these statements that didn't come in. So I'd suggest to the court that the Fourth Amendment challenge to the extent there is a clearly delineated Fourth Amendment argument about the statements raised in the briefing, I'd suggest that it's waived. It does not appear, I can't see the original legal pleading, so I can't necessarily say that it was preserved at trial. It seems probably from the motion to suppress transcript that it was, but it certainly doesn't appear in the motion for new trial itself. And the transcript doesn't include these statements. And Your Honors, it's a relatively common tenet of appellate law here in Tennessee that issues not preserved in a motion for new trial are waived. I understand this court would have the discretion to review these for plain error. I'll note that hasn't been requested. So I believe the Funk case is the one I cite to in my brief, but this court would be well within its right to not subject this issue to a level of review that the defendant hasn't requested. So I'd contend to the court that the first of the identified Fourth Amendment issues about the statements is waived. I'm happy to discuss the merits of that claim, but in the context of plain error. But as Your Honor noted, it hasn't been requested, so the state's principal position would be that this court should not review this statements issue at all, because it hasn't been preserved and plain error review has not been requested.
Where was Kelly when the officer searched her car? Was she still inside the store?
No, Your Honor. So all of the interactions between law enforcement and Ms. Kelly, and indeed the defendant, happen outside the store. Ms. Kelly, at the time Officer Gwynn is talking to her, is on the sidewalk, sort of up against, like standing beside there's like a McDonald's side of this Pilot Travel Center. So she's standing near the door to a McDonald's, I'd say 8 to 10 feet from her car. The defendant is standing closer to the entrance to the Pilot. So that's where the video will reflect she is. She's not in the store really at any time. The only person in the store in the video is the defendant, because there are a couple of times where he does walk back into the store and walk back out. Turning, Your Honors, to the Fourth Amendment issue that I do think has been preserved, and that's the one regarding the scales. I'll note that at the time the scales are seized, the defendant has been arrested. So this is a search incident to arrest discovery. What isn't at issue in any Fourth Amendment thing related to these scales is this sort of initial seizure of the defendant. The defendant is told, I believe 15 to 17 minutes into the supplemental video, and if my memory serves me a little wrong there, I'll apologize, but he's told at some point during this video he's free to leave. And indeed, it appears he felt he was free to leave. He wanders out of screen, goes into the store. We can hear at a couple points him arranging transportation. So he's leaving.
Wasn't his parole card still retained, though? I mean, it'd be like in Daniels, if the officer in Daniels said, "Well, I still have your driver's license, but you're free to go, but I'm going to still keep your driver's license."
So I think there are a couple of distinctions to draw from Daniels, Your Honor. One is certainly Daniels does say when a driver's license is retained, that effectively immobilizes the defendant. I think the first distinction is that this isn't a driver's license identification. This is some other form of identification, and the record indicates that it's expired. When the defendant hands over this, I think the defendant describes it as a parole card. I'll be candid with the court. I haven't actually seen this form of identification. It's not in the record. And although the entire interaction is copied on body cam, it's not as if Officer Arnold is sort of holding the ID up in front of his body cam. So I can't say exactly what this identification is. The defendant describes it as a parole card when he hands it over and says I believe he says the exact phrase he uses is no longer valid. So it is an expired parole card. I think that's qualitatively different from the driver's license in Daniels that the court said effectively immobilized the defendant. I think this is pretty different, and the defendant clearly felt it was different. He didn't feel immobilized. He started making arrangements to leave, as I think any reasonable person would feel in this situation. They've been told to go, or they've been, told that he's free to go, and he begins to do so. So where I think the Fourth Amendment meat of this issue is was there a lawful search, or was there a sort of a lawful arrest? And Your Honors, for some of the reasons that I've explained to this court, mainly his statements about driving, there's probable cause to arrest him. I don't take there to be any serious dispute in this case that Ms. Kelly and the defendant arrived at this gas station in the same car. Both of them make statements to that effect throughout these videos. During a search of this car, both cocaine and a stolen firearm are discovered. To meet the probable cause threshold, we're not establishing sufficiency of the evidence. This isn't beyond a reasonable doubt. Beyond a reasonable doubt, we're dealing with sort of articulable suspicion to establish, the facts that would constitute the crime. We have that in this case. At the moment of arrest, the defendant has admitted he was in the car. He's indicated he was driving the car, and the gun and cocaine aren't located in a locked container in the backseat. They're not in the trunk. They're right front and center, in easy access of the front seat occupants. So I'd suggest to the court that there is probable cause to arrest him at that time, and then obviously once he's arrested, the search incident to arrest quickly discovers the scales, and that's not in and of itself an issue. If this court has any further questions, I'd be happy to answer them. Otherwise, I would ask that you affirm the judgment below. Thank you, Your Honors.
Your Honors, I would like to, well, first, I want to make sure there's a couple of points I disagree with, and this again goes back to, I think, what happened at the trial court level, and that is the assumption and the glossing over of the actual language used and the interaction between Officer Arnold and Mr. Chism. And that has specifically to do with he was driving. I mean, counsel has correctly noted that, or has again reiterated, and what I don't want to become a accepted fact in this court, and I don't think should have been at the trial court level, is that Mr. Chism was driving, because I don't think the facts support that. Second, Your Honor, with respect to the seizure issue, Daniel specifically, and I don't have the exact quote, but Daniel does note, State v. Daniel does note that a person's, with respect to seizure, it doesn't say a person's license. It doesn't say a person's valid license. It specifically says a person's identification or other property. I believe that's the exact language, and I believe that this qualifies as that for the purposes of a seizure. And I think as this court has raised the issue of, well, these scales are inextricably linked to the cocaine. Well, the jury clearly didn't think they were inextricably linked. And I'd make some points about this. One, I think I used in my brief I did something wrong as a defense attorney. I used the bigger number as opposed to the smaller number. I said 11 centimeters. 11 centimeters is 4 inches. We are not talking about a very large gun. We are talking about a gun, quite frankly, that would have fit very easily in Mr. Chism's pocket. Talking about 6 grams of cocaine. Another thing that could have fit very easily in Mr. Chism's pockets. I think in terms of inferences, it doesn't make any sense to draw the conclusion why he has one thing that fits in his pocket and not 2 other things that would, as the state would say, naturally go with it, not also on his person. This was not his car. He did not possess the key fob to this car. He was not under, I think in terms of an inference, he was not under the under the influence of the substance that was found in the car. The state did not test those scales for the residue of those scales to determine whether or not it was cocaine. Miss Kelly had other drugs in her purse, and that frankly formed the basis for the search of her car. She had, and I get this confused, she either had alprazolam in an oxycodone bottle or oxycodone in an alprazolam bottle, either way, on drugs that were not prescribed to her. And furthermore, Your Honor, I think that in addition, the state did not seek, and neither did Officer Arnold, seek the video of the pilot travel center. A lot of these questions could have been answered, and they were not. And so there's lots of assumptions about how long were they there? You know, what were they doing before they got there? Who was driving? That I don't think can be drawn. Furthermore, and I note this in my brief, Mr. Chism's phone was searched. And I think that if we were to talk about this in a general sense of what does this look like, if we were to step back, the reasonable inferences are that this is not Mr. Chism's gun. You watch him on the video. He doesn't care that they're searching her car. She strenuously objects. His interactions and his entire demeanor is, you know, hey, it doesn't look like a gun that he, I'm not going to go there. It is a tiny gun, and you can see him he's a pretty normal sized dude with fairly large hands. I mean, I don't know as though that is an effective weapon for him. Just as a common sense matter, the inferences that are there draw the conclusion that it's not his gun. And with respect to the state's only tenuous, really the state's only continuous contention, well, sorry, the connection is he was driving, and Siner notes that driving can make a difference. It is certainly not dispositive. And the federal case law that I've cited clearly says it's not enough. There's a knowledge component. And I think the cases that have found where a driver is, you know, can constructively possess something truly focus on have additional facts as to why that person has control over the entire car that are absent in this case. Thank you, Your Honor.
Thank you. All right. Thank you for the arguments today on this case. Call on this case, please.